A very good evening from all of us here in India. Thank you so much for taking the time to attend our webinar today. At the outset, I hope all of you are safe and well wherever you are. A discussion on healthcare and life sciences couldn't be more timely. With more governments across the world grappling with the challenge of prevention and cure, any debate on healthcare presently seems the most sought after. This evening, we will though take a slight detour for the topical discussion on vaccines and PPE to the one on medical devices. India is a $5 billion market and is the fourth largest market for medical devices in Asia. 80% of this market is serviced by imports from the US, Germany, Japan, China, and Singapore. The Indian healthcare sector is still, in a way, stuck in its archaic form and mode in terms of reliance on written prescriptions, sales through brick and mortar pharmacies, in-person consultation with doctors. With the evolving economic, social, and healthcare landscape, the Indian medical devices market is expected to grow to $50 billion by 2025. Given the promising potential, the Indian government has taken steps to promote medical devices industry with a new regulatory framework. Under the circumstances, the digital healthcare market comprising telehealth, telemedicine, mHealth, electronic health records, medical records, remote diagnostics, healthcare analytics, has a huge potential to revolutionize Indian healthcare by leveraging the high mobile and wireless density. In recent years, India has seen a notable penetration of personal well-being applications ranging from symptom checkers, doctor finders, condition monitoring and management systems. Yes, the Indian opportunity looks promising, but the latent industry challenges are critical issues that any foreign investor will have to closely bear in mind. This evening, we hope to cover a lot of interesting topics in the context of medical devices and personal well-being applications in India, primarily those around regulation, data privacy, intellectual property, and foreign investment. We've got a very interesting panel of lawyers from Khaitan and company, each one of them a subject matter expert on some or the other form of regulation. Let me introduce our panel for today. Samir Shah is a partner with a corporate commercial practice. He specializes in life sciences as a subject. Shupratim Chakrabarti is our data privacy partner. Adish Nargolkar looks at intellectual property as a subject. And Sanjay Khan looks at regulation in addition to his corporate partner responsibilities. Before I start the webinar today, let me try and spell out some of the housekeeping rules for today. You're listening to this webinar in the listen-only mode. Should you have any questions, please type them in the chat box mode on the screen in front of you. We will try and answer as many questions as we can in the course of this presentation. Let me first invite the first speaker, Samir Shah. Over to you.
Thank you, Gautam, for that very interesting introduction. And in fact, I will pick up from what you just spoke about in terms of personal protective equipment and masks and ventilators and things of that nature. And mind you, the regulatory developments I will start with also potentially affect personal protective equipment, masks, and ventilators. So if you're a software developer or if you're developing applications, you may actually wonder why is there a relevance of discussing medical devices really? And that's where, as Gautam mentioned, there have been some very recent developments which could potentially require a lot of thought and a lot of discussion in terms of compliance. The slide that you see on your screen shows the march of how regulations have really evolved. And the point and perspective really is that traditionally, India's idea of regulating medical devices was to, in fact, not regulate them. And that introduced a lot of self-regulation in the market, because that meant that sophisticated users would tend to demand either US FDA certification or European certification. And that brought in a certain level of uniformity of standardization, um, save and except some very specific kinds of devices which the government decided to regulate. So then you had things like syringes or sutures or the lens that goes into the eye in a cataract operation. So things that literally look and feel and sound like a medical device. Um, all of these were regulated as drugs, and drugs not in the context of our more narcotic cousins, but drugs as in pharmaceuticals. That's the term of art Indian law preferred. All of these products required licensing for manufacturing, for trading, for imports, and their safety and efficacy was tested from time to time. However, as Gautam explained, India still continues to be a very large a very large import focused market in terms of meeting our domestic needs, which is very contrary to our position as the pharmacy of the world when you look at the pharmaceutical cousins. So from that perspective, one of the major issues was there weren't any domestic standards. The government introduced certain rules in 2017, gave it one full year before those rules became valid and applicable. But bear in mind, the list of devices which they covered still continued to remain very small. It's gradually increased, but if you look at it from the context of how medical devices regulation works in other countries of the world, the list was never nearly as expensive. So in that context, in February 2020, a new definition was introduced, which covered almost all forms of devices which were in any way dealing with the treatment or the diagnosis or in any other way linked to a disorder. So from that perspective, really, you would see an MRI machine, you would see a CAT scan machine, you would see a portable ECG device, all of these more medical sounding terms clearly getting caught in the definition of medical devices. But bear in mind, one very peculiar aspect of this definition, which has become effective from 1st April 2020, is the fact that software is also included in it. Before we move forward and discuss a little bit about the software context, this definition, even though it came in February 2020 and became effective from 1st April 2020, it's very possible that being lost in this entire pandemic issue, not too many people have had the chance to focus on this definition and align themselves from a regulatory perspective. I gave the example of masks and personal protective equipment. It's something which has probably slipped under the radar due to more urgent priorities. But bear in mind, the government is aware that not all such regulations can immediately be aligned to. They have introduced a process by which manufacturers and importers can register their devices with the government. And registration, if accepted, entitles them to a certain exemption over a period of time. As far as software as a medical device is concerned, this does pose certain challenges, as I had explained. First and foremost, the largest challenge is what category of risk are they classified under? Under the medical devices rules, there are 4 categories of risks: Class A, Class B, Class C, and Class D. But as far as software are concerned on a standalone basis, they have not been put in any of these 4 categories. Therefore, it's very unclear as to what is the category of risk, whether low moderate, whether moderate high, whether high, these devices would fall under. The result of this as a cascading effect is that it is unclear what standards should one apply. It is unclear what guiding principles and exceptions apply to such devices. This is more relevant in the context of startups, because if a vast number of applications and software, particularly applications which are downloaded and used on your phones, are developed by the ever growing startup ecosystem which exists both in India as well as abroad. So in that entire sphere, it's quite unclear as to how, if you are a software developer sitting in the Western world but offering your software and your application to users in India, what regulatory compliances do you have to undertake and what regulatory compliances do you not have to undertake? It involves a very massive fact specific analysis and also potentially involves a dialogue with the authorities. But speaking of authorities, it's very critical to also note that Now, since these devices will be treated as drugs, they will be subject to what is called price control in India. In fact, on the 31st of March, in the midst of this entire pandemic lockdown, the relevant authority, which is the National Pharmaceutical Pricing Authority, did provide a clarification that all devices which are now covered because of that definition will get caught in the price control net. So, how does price control work in India? As far as price control is concerned, there are essentially two categories of products. One is what is called scheduled formulations. Obviously, it's very difficult to imagine a software or, for that matter, a tangible device as a scheduled formulation. Again, a product, again, it is a term which is probably more in vogue for the pharmaceutical products. But at the same time, it is known to cover other medical devices uh, which have in the past been treated as essential medicines. Likely that software will not fit in that particular sphere, and therefore the chances of software being subjected to that kind of pricing are slim. Now bear in mind, the pricing which is relevant for scheduled formulations forms a ceiling price and therefore acts in a way which covers your top line if you are a medical devices manufacturer. What is more probably relevant is non-scheduled formulations, because for non-scheduled formulations the requirement is that you cannot increase your prices beyond 10% of what they have been in the last 12 months. Now 10% as such sounds like a fairly significant number, but bear in mind again that when you are looking at software and applications which are sometimes offered for as low as $10 on an Apple iStore or on a Google Play Store, a 10% of $10 is a mere dollar, and which may not sound as much when you look at it in a contextual circumstance. So with that, I would like to hand back to Gautam to see how we'd like to take this forward.
So, very interestingly, there's a few questions that have already come up on the chat board here. Let me try and see whether I can maybe try and address a few of those. The first obvious question is this registration compulsory? Let me add a couple of more questions to that. Second question is, how does the exemption work? And the third is, how long is that exemption valid? Go ahead.
Very interesting questions. So first and foremost, I must say the rules work very hard to keep all of us lawyers in business. And while they specify that the registration is optional for 18 months, if the registration is not done and the exemption is not availed, the medical devices rules become applicable to all devices from 1st of April 2020. So on the first question, while it is indeed optional, by implication it's been made mandatory. In terms of the time that is available, if you go back to what I was explaining on the classification of devices, if a device is classified as low risk or low/moderate risk, which is classes A and B, then the exemption is available up to 30th of September 2022. But if you're in the moderate high or high category, which is classes C and D, the exemption is available until 30th September 2023. So therefore, eventually compliance is forthcoming. Now, as far as registration itself is concerned, it asks for a fair amount of mundane detailing, whether you're manufacturing in India or whether you're importing from outside into India. But the most difficult part really seems to be that there is an ISO standard compliance which has to be certified. Now, when you're talking about traditional medical devices, no problem. This is something which people should definitely be able to do. And maybe it may pose some issues as far as the smaller manufacturers are concerned, but with time, it's something they can upgrade to. However, when you look at application developers or software developers, this really begs the question whether they would have undertaken that level of ISO certification or not.
Very interesting. Another question that's come up is, does it apply only to new devices or does it have a retrospective effect too?
Well, that is one of the major issues which we were perceiving, and maybe in the COVID madness that isn't being enforced in the same level. It doesn't apply only to new devices, Gautam. So it in a way also applies to the inventory which gets imported into India after 1st of April. it also gets applied to inventory which gets manufactured after 1st of April, even though similar inventory may have been manufactured in the past and is being identified in the future. As far as inventory which is already in the market, one was hoping for some sort of a clarification. But if there is inventory from the past and that has not already been sold downstream, it requires relabeling, because this exemption, which is supposed to be availed, it will provide a particular acknowledgement number to the relevant applicant, and that number has to be then labeled upon those devices. So the short answer is yes, it applies to everybody. It probably would find that much more difficult to apply to inventory already in the market. But even though inventory may have been supplied in the past, those devices are subject to these rules.
So there's a flurry of questions coming as I'm talking to you. The last question, that we'll go to the next speaker here. This is about price control. Now, you said even medical devices will come under the ambit of price control. Looks a little tricky here. Talk us through some of the implications of breaches if some of these companies were to commit those knowingly, unknowingly.
Well, the breaches can be very significant, and the issue is obvious. The obvious consequence would really be recovery of the overcharged amounts. And believe you me, especially for non-scheduled formulations, it's very possible that breaches may slip under the radar for some time, which means suppose in year 3 or year 4 is when they've realized that, well, instead of 10%, you've been charging 20%. Then the balance 10% is subject to a recovery back to them. Now, a lot of that money may already have been spent in the system and may not be available for forking out. In addition, there could be fines and penalties, because this entire concept of price control emanates from what we call an essential commodities legislation. And there are some fairly stringent fines and penalties to be had. So people really need to be mindful of this going forward.
Good. Thank you. Sumit. What I'm going to do is I'm actually going to move on to the next speaker now. And if there is time at the end of the whole session, I'll surely come back to a number of the other questions that are still pending here on my side. Let me now invite the next speaker on our panel today, which is Supratim Chakrabarti. Supratim is a specialist on data privacy. He's done extensive work on GDPR. And now we're talking about India coming with its own regulation around data privacy. He's at the helm of all that. Over to you, Supratim.
Thank you. And yes, I think no discussion on digital well-being application can be complete without discussing data privacy and protection, which is in the helm of things, as you correctly mentioned. As you are aware, the entire business model of personal well-being applications is very data intensive. And data privacy and protection, therefore, is absolutely non-negotiable. Interestingly, most of the data that is collected is categorized as sensitive personal data. Whether it is the present day law in the country, whether it is the upcoming law in the country, both of these, categorize majority of the data as sensitive data. And therefore, there is a requirement to follow higher standards of security. As far as fines for breaches are concerned, as far as today's law is concerned, there is an uncapped bucket, and therefore we have to be extremely mindful and careful about it. And upcoming law, of course, has a more stringent and rigorous take on this as far as fines and penalties are concerned. So with that, I'll quickly jump on to some of the slides here. So this is what is sensitive data today under Indian laws. On the left-hand side, if you see, is the existing law that we have, and what do we consider as sensitive data today. If you see, a number of these elements are extremely relevant for personal well-being applications, like physical, physiological, mental health conditions, sexual orientation, medical records and history, biometric information. Going forward, on the right-hand side, you'll see what is there in the upcoming Personal Data Protection Bill as sensitive data. Well, elements such as health data, sex life, sexual orientation, biometric data, genetic data, intersex status, transgender status, all of them. So you can clearly understand how critical is data and its safeguarding as far as these applications are concerned. So what we thought is we should discuss a bit about what do we have as a law on a sector neutral basis, because see, there is no specific legislation today in relation to personal well-being applications and their handling of data. Therefore, the Information Technology Act and some of the sections and rules under it really give us the relevant guidance. So this section 72A talks about handling of personal information, and what should you be doing? You should be protecting it properly. And if there is any disclosure without the consent of the person concerned or in breach of a lawful contract, then there could be imprisonment up to 3 years. There could be fine up to 5 lakh rupees or both. There is another section, which is section 43A, which deals with sensitive personal data. And it states that you have to have reasonable security practices and procedures followed in relation to sensitive data. If wrongful loss or wrongful gain is caused to any person because of any kind of breach, then damages are payable by way of a compensation. Now, a very interesting thing here, you may note that when GDPR, the European Union's General Data Protection Regulation, came into effect, several entities in the country sat up and took note of it, okay, especially the ones who had some interface with the European Union. And we saw them following some of the requirements of EU GDPR. Interestingly, the reason why they were following it is because of the high thresholds of penalty. Look at this. We always had provisions under Indian law which were uncapped, and still perhaps not many were aware of it. Perhaps there was inadequate sensitization or improper implementation, but all of this is supposed to change right now. The upcoming Personal Data Protection Bill is trying to wash out all these old aspects that we want to forget soon and get into a new regime which is world class. So the next aspect that I would like to talk about is there is a set of rules in relation to sensitive data, and it spells out what exactly you should be doing when you are handling sensitive data. Well, you should ensure that the information provider is aware that the information is being collected, the purpose of collection, the intended recipients, and name and address of the agency that is collecting and retaining the information. Very often we see that this aspect is missed out by organizations and they'll end up in trouble. Sensitive data should be retained only for a period that it is required, and you should also give the right to the individuals or data subjects or data principals, whatever you call them, to withdraw permission if they so want, and also allow them to review and amend if they so want. Consent and notice are two different things. I would like to touch upon this slightly. You should ensure that appropriate, clear, and prior consent is taken in relation to usage, the purpose of usage of the sensitive data. And if you have to disclose this to any other third party, you can do so, but ensure that this is as per the agreement or the consent that you have taken from the individual. Of course, government agencies have a leeway if they are mandated by law. Few other things that I would like to touch upon are firstly transfer. A lot of questions come to us in relation to transfer of sensitive data from A jurisdiction to B jurisdiction. Is it permissible? Is it possible in your jurisdiction? The answer is yes, today it is permissible. Even if it is sensitive data, no problem at all. But few things to be kept in mind, and that is you have to ensure that the recipient is also following the same kind of security norms that are set out in these rules. You have to ensure that the information provider, whatever consent you have taken, agreement you are following that, and it is akin to that consent that you have taken. Privacy policy is a must. Many times we see long-winded privacy policies, but some of them miss the most obvious points that should be there. So what does the law say in case you are handling sensitive personal data? You need to ensure at least these points to be there. The type of information that is collected, the purpose of collection of the information, the security practices and procedures that are followed, and the disclosure policy of the organization. Now, security practices and procedures in this bucket, the privacy rules state ISO 27001 as one of the specified security norms. You have to have a grievance officer. Thankfully, there is no specific threshold given that this person has to be a tech guy or a legal person. It can be anyone who's able to address the grievances. The name and contact details of this person has to be published on the website, and the officer has to redress the grievance within 1 month. So with that, I hand it back to you, Gautam.
Thanks, Shrupatin. Data privacy too events a lot of questions here. Like I did in the earlier case, let me try and maybe pick out 3 or 4 questions now and then leave the rest for later. The first question, an interesting one. There's a discussion happening about this new data law. Question is, what about the number of data subject rights? How does that all work in the overall scheme of things?
Right. No, I think very good and pertinent question. A data subject, let me not call him subject. In fact, Justice Sri Krishna said that after the Britishers went, I would not like to call any Indian a subject. So we have called them data principals. Data principals have a lot of right under the new bill, and these are quite akin to the rights under the European Union's General Data Protection Regulation. These are, right to confirmation and access, right to be forgotten, right to portability, right to correction and erasure. But believe me, what is extremely different from what the global laws are stating are these, okay? Right to be forgotten in our jurisdiction is not right to delete everything to the last dot. Thankfully, we have not aped global jurisdictions. We have been part of almost all the consultation meets that happened when this law was getting drafted. And the tech guys raised a question that in today's world, it is quite difficult to really vouch that I have deleted everything, every iota, every single detail about an individual from my system. So therefore, the discussion evolved to state that, okay, what is the menace that we are trying to curb? And perhaps that is a right against further disclosure. And that is how it is drafted in our law. Right to be forgotten is actually crafted in a manner which states it is a right against further disclosure. Very interestingly different from GDPR, I would say. Also, globally, there is this whole new norm which is developing on data portability. Very simple terms. If you go to, say, Bank A and you give your credentials, your PAN number, Aadhaar, etc., open a bank account, then you go to Bank B and then do the same thing. You submit all these documents to open another bank account. The question is, why shouldn't we have a system where the data in a machine readable format moves from Bank A to Bank B if you have given the authority? And that is what is sort of coming into play under the new bill. The rest of it, I think, right to confirmation, access, correction, and erasure are self-explanatory. I'm not going into greater detail there. Thank you.
Another question is on data localization. Big discussion happening around the Indian government regulation insisting on localizing data. What happened in the context of personal well-being applications? Will you have to localize data in that instance also?
Yeah. So Gautam, I think again, very pertinent question, and the discussion has evolved over time. When the first version of the personal data protection bill came out, it had localization written all over. Okay, so basically every personal data kind of had to be housed only within the country. But there was a lot of deliberation, discussion, pressure, and then we see a new version which has come out, which is Personal Data Protection Bill 2019. In that, what they're stating is that if it is only personal data, it can go out of the country, no problem. But if it is sensitive data, then it has to be housed within the country for certain processing purposes. Of course, it can go out. There are certain norms which are set out. Then there is a bucket called critical personal data, okay, which can never leave the country. There's a very minuscule avenue left for that transfer, but that is immaterial for today's discussion. Thumb rule, what I would state for purposes of personal well-being application, I think there should be a very clear demarcation between personal and sensitive personal data. In all probability, you will have to house the sensitive personal data within the country if the present bill is to fly the way it is, and that has to be handled differently from only personal data which can go outside the country freely. Thank you.
Just one last question, Shrupatin. This is about personal data protection law. Now, there is also a proposed specialized law on digital health data, DISHA as it's called. There's a big discussion happening on Arogya Setu also in the Indian context in COVID times now. Can you help us understand a little bit more in terms of what is this personal data protection law, and a little bit on DISHA also?
Yeah, so I think we are truly missing a specialized law, Gautam, today in the pandemic situation also, because a lot of this health-related information is being obtained, transacted, processed, etc. But there is no clear legal stipulation, so to say. Of course, there's a patchwork of laws which are trying to cater to this situation, but this does not have aspects such as pandemic or epidemic. And therefore, we are relying on our regular laws to attend to the situation. Our personal data protection bill, which we have been working very closely on, is still in the making. It's supposed to be tabled in the parliament. The Joint Parliamentary Committee is presently looking at it, and they were supposed to give their report to the parliament during the monsoon session. Let's see where it is headed. Apart from that, Ministry of Health and Family Welfare sometime back had come out with a law called on digital health data, which is called DISHA. Of course, it was not very happily worded, and there were inputs which were taken from the stakeholders. But after that, we did not hear much on that. I'm not sure whether that will see the light of the day.
Thank you. As Samir mentioned in his presentation, medical devices include softwares alone or in combination. And therefore, the first and foremost question that comes to the mind is patents. Under the Indian patent law, a patent application is substantially examined for novelty, inventive step, and industrial applicability. Basically, the three criteria of patentability are in line with major patent offices across the globe. What is typical from an Indian perspective is Section 3 and 4, which talk about what relates to non-patentable subject matter. To put in perspective, in addition to the three criteria of patentability, the invention must not fall within the ambit of a non-patentable subject matter. Now, when you are talking about pharmaceutical inventions, Section 3D is often cited by the Indian Patent Office. When you are talking about medical devices, it is Section 3I, which is generally cited by the Patent Office. On the reading of Section 3I, it is clear that the section intends to prevent any method or a process for treatment of humans or animals. However, it is common to see that Section 3I is cited by the Patent Office as an objection when we deal with medical devices related inventions, especially when it is in relation to a process or a method claims. In our experience, 3I is generally not at all a red flag when we are talking about a medical device which claims to claim a device and not per se a method or a process. In other words, if you are claiming only a method or a process for treatment, then it may not sail through. With the new notification and advent in the medical devices technology, softwares are now integral part. For example, pulse oximeters to surgical robots. Like all other jurisdictions across the globe, the question of software patentability is a pertinent question, and therefore Section 3K comes into picture. Moving on to the framework revolving around 3K, it is well known that Section 3K, that is computer programs per se or algorithms, are not a subject matter of a patent. The Delhi High Court recently, in the matter of Ferid Alani, observed that this bar on patenting is in respect of computer programs per se and not on all invention based on computer programs. Now, this introduction of per se was by way of an amendment in the Act to ensure that genuine inventions based on computer programs are not refused as patents. The Delhi High Court also referred to guidelines which were published by the Indian Patent Office for examining the computer-related inventions. Interestingly, the first guideline defines technical effect, whereas the same is not to be found in the other guidelines. If we see the definition of technical effect means a solution to a technical problem, and the examples include higher speed, reduced hard disk drives, more economical usage of memory, etc. It also defines technical advancement as contribution to the state of the art. The court clearly set out that there is no absolute bar on patentability of computer programs, and to that extent, the Patent Office must inquire into the technical effect or technical contribution of the invention in question. Moving on, let us discuss the possible scenarios of patentability of such medical devices, which include softwares. Now, the first option before us are medical devices such as syringes, stents, etc., which are basically medical devices without a software. And therefore, the question of patentability does not arise at all. However, the question of Section 3K or the Indian Patent Office objecting to 3K is likely to remain in the other scenarios. Let's discuss option 2 and 3 by taking an example of, say, a digital thermometer. In one scenario, we have a digital thermometer having a novel sensor arrangement, and in the other scenario, we have a known digital thermometer with a new software, which makes the digital thermometer having certain advantages, say, for example, more accurate, quicker results, etc. This aspect is where the debate is, and the stand taken by the Indian Patent Office is unfortunately a bit inconsistent. We are hopeful that after the recent Delhi High Court judgment, there is some clarity. Moving on, the name and logo used in a medical device can be protected under trademarks or copyrights. When you're looking at a source code or object code, it can be protected by way of a copyright or a confidential information. The steps performed by the code are protected under the patent law. Documentation or database can be protected as a copyright or can be considered to be a confidential information. The graphical user interface or the layout of the app can be considered to be protected under copyright. The aesthetics of the device or the system can be protected under design. As discussed in the previous slide, various intellectual property rights can protect a single product. However, the same needs deliberation, and there are certain provisions which may impede simultaneous protection. Prior disclosure or launch before filing a patent application can pose a genuine threat to patentability of your medical device. Hence, filing of the patent application must precede any disclosure, launch, or any regulatory filings. Also, and this is typical when it comes to the Indian patent law, is the foreign filing license, that is FFL, wherein, assuming for any reason a decision is taken by the company to file any patent application outside India, and there are Indian residents who have developed the invention for which the patent is to be filed, a foreign filing license needs to be obtained from the Indian Patent Office. And contravention to such a provision is onerous. There are fines as well as its imprisonment also can be levied. Now, companies also need to be aware of the ownership issues that may arise during the life cycle of the entire invention. It is common to have various developers working on softwares. Some of these developers may be employees and some may be third-party outsourced consultants. Now, unfortunately, the leakage starts when you are developing the invention, and that is at the developing stage. And therefore, it is extremely critical to identify the resources and have confidentiality agreements, as well as assignment agreements with these third parties to ensure that the ownership is protected and transferred to the company. Another issue which might arise is on the ownership of the IP in the parent company when the employee of the subsidiary creates the software. Now, the creator of the software is the employee of the subsidiary company, and by virtue of the Indian Copyright Act or the employment agreement, the subsidiary company would be the owner of the IP. And therefore, for the parent company to get ownership, the two entities need to have an agreement, whereas the subsidiary will have to assign these rights to the parent on an arm's length basis. Thank you, Gautam. Over to you.
Thanks, Adish. Adish, a few questions that have come in on IP too. The first question is a very interesting one is, well, this section 3K that you spoke about, is that typical to India, or you actually see this kind of a section prevailing in other parts of the world too?
Okay. Now, I'll just answer this question by going back a bit to the history. As you all might be aware that India is TRIPS compliant, as is the case with all major jurisdictions across the globe. And the TRIPS agreement does not provide for any of such exclusions like we have in the section 3, that is the 3I and the 3K that I spoke of. And the country, each country is given the flexibility to exclude the subject matter from the patentability in order to maintain public order, etc. For instance, Europe also excludes softwares from patentability and requires that a technical effect or technical contribution must be shown. Now, US does not specifically exclude any software, but we have seen that the examiners have raised objections, and after the Alice judgment, US also has been not very cooperative when it comes to granting the software related inventions. So if I may say, it is certainly not a cakewalk when we are talking about other jurisdictions, even if they don't have that provision.
Very interesting. There's a big discussion happening around guidelines for examining CRI, computer related inventions. Now, are these binding on the examiner? Rather, has this brought about any consistency in the examination process?
Well, the guidelines, Gautam, are not binding on the examiners. Having said that, they are supposed to refer to those guidelines. But as I mentioned, they are not binding, and which is where there was a gray area. But I'm hoping that post the December 2019 judgment by the Delhi High Court, there would be certain clarity on the same.
Another question, should one wait for the regulatory approval and then file the patent application? Or you can do that separately?
Well, when you are filing a patent application, and now it is mostly across the globe, that is the first to file, and therefore applicants need to get a priority by filing a patent application because it's not first to invent but first to file, and therefore it is important that the applicant needs to file as soon as possible and not to wait for the regulatory approval.
Last question, Adish, from in this section here. There's always a typical preference interest to file in a major jurisdiction like the US. Can a company strategically decide to file only in the US?
Well, if the company wants to file only in the US and there are inventors who are resident Indians, Then, as I mentioned, a foreign filing license needs to be obtained by the company before it files an application only in the US and not in India. Otherwise, the law provides that the application wherein the inventors are residing in India needs to be filed first in India, and then after a certain period, the company can go abroad and file.
Very helpful. Thanks a lot, Atish. With that, we go to the next section, which is going to be done by Sanjay Khan Nagra. And Sanjay is going to touch upon a very important aspect of foreign direct investment, foreign investment regulation, that a lot of players from other parts of the world are quite eagerly looking at in the Indian context. Over to you, Sanjay.
Thank you. I will now quickly touch upon certain cross-border aspects to be kept in mind by technology companies and startups in particular. We see a lot of technology companies and startups having products and softwares which are likely to be considered as medical devices, as Samir discussed in his section. Most such companies are likely to have foreign capital on their cap tables, whether as foreign private equity or venture capital funds or as foreign strategic investors. In many cases, they are also subsidiaries of foreign tech companies which are functioning in India. Let us now begin with FDI aspects, which is foreign direct investment aspects in particular. On the left side of your screen, you can see the regime for FDI in manufacturing of medical devices in particular. India has had a manufacturing FDI regime always. This is a sub-segment of it and also a sub-segment of India's FDI regime on pharmaceuticals. 100% FDI is allowed under the automatic route for manufacturing in medical devices. Medical devices definition for FDI purposes also includes software. Therefore, that aspect is specifically covered for. Another thing to keep in mind is that FDI in pharmaceuticals in general is not so liberal. Historically, pharmaceuticals has been a restricted sector which has been opened up over a period of time. Right now, FDI in pharmaceuticals has certain conditions which are not applicable to FDI in medical devices. Conditions such as any non-compete agreement in relation to FDI in pharmaceuticals requires prior approval of the government. All inter se agreements between parties in relation to FDI in pharmaceuticals also need to be submitted to the government. Such conditions, thankfully, are not applicable to medical devices. On the right side of your screen, you can see FDI in trading. This will apply to those companies who do not fall within the category of manufacturers, so to speak. Trading is divided into two buckets: business to business and business to consumer. Business to business trading and business to consumer on a single brand basis. Single brand, which means globally the goods are sold under the same brand. In these two conditions, FDI under 100% automatic route is permitted. B2C FDI, on the other hand, multi-brand retail as we call them, is strictly regulated. The condition right now is that any FDI in multi-brand retail trade requires prior approval of the government. As a corollary to it, any multi-brand retail trade done online by way of e-commerce also requires a prior approval. This is very important for software companies in particular who sell their software online. And therefore, what can be done is that Indian companies which are running e-commerce platforms, they can run e-commerce platforms in marketplace model. In other words, they cannot have control over inventory, and so long as they're only connecting buyer and seller, they can do so. Moving on, we will now discuss cross-border trade and investment options. With respect to cross-border trade, for both import and export, there are certain nuances that one must keep in mind other than routine filing and paperwork, which we will not get into. Firstly, for any import or export transaction which is with a related party or a group entity, one needs to do what is called as transfer pricing study, which also means that you need to ensure that the transactions are done on an arm's length basis and not really on any commercial terms. These transfer pricing studies are a routine business activity for Indian companies with foreign subsidiaries, foreign companies with Indian subsidiaries, and therefore they need to be complied with. The second aspect is about export of software. This applies to companies which are in India developing software which could be categorized as medical devices and exporting it to foreign audience. They need to collect their payment in advance or within 1 year of the export. Third aspect applies to import, and this is slightly critical in the given scheme of things, since a lot of medical devices in the nature of software are likely to be sold by foreign players to Indian audience. Those health tech companies which are sitting abroad and looking at India as a market for their medical health tech devices, they need to be cognizant that in India now in 2020 there is something called as an equalization levy, which means that any product which is sold online, whether it's a good or a service or a software, if it is sold online to an Indian customer, then there is an additional 2% equalization levy tax which is payable. Historically, what is being paid is a 10% royalty, and that's a debatable concept. But if one imports software in India, a 10% royalty withholding tax was to be paid by the importer. Now there is a debate around equalization levy and this withholding tax, but hopefully there will be some clarification around it very soon. To quickly wrap up the fourth and final point around the common financing rules. Generally in India, foreign funding comes either by equity or debt. Both of them have certain requirements which are slightly cumbersome as compared to other jurisdictions which are developed. For instance, India does not have complete capital account convertibility. Therefore, it requires valuation to be done of the Indian company before equity funding is raised, and equity funding from foreign source can be raised only above the fair market value. For debt, there are stringent requirements about minimum maturity period and maximum interest that can be paid. One last thought I will leave all of you with is the startup regime that India has come out with. It is to promote startups in India. And if there is any startup which is registered, there is a registration process. If you are a registered startup, then you can take advantage of what is called a convertible note. Convertible note is a mix of equity and debt. It doesn't require valuation, but it also gives you the features of an equity instrument with the protection of debt. With this, Gautam, I will give it back to you and we'll start with Q&A.
Thanks, Sanjay. I think it's a good way to really try and round up pretty good discussion. We started with the regulation on medical devices. Then we went on to a very interesting discussion on data privacy. From there on to IP and now the investment in India. You spoke about, a lot of investment you see happening in the software business in India. In your view, what are the 3 top challenges you've actually heard a lot of your clients discuss in the context of FDI in Indian software?
Let me divide that, Gautam, in 2 parts. With respect to FDI, the biggest challenge as of today is about how do you sell your products online. Any online sale of any products require maybe an e-commerce platform, which are nowadays very common. In any e-commerce platform, if you're selling your products, you need to ensure that you yourself are selling. If the e-commerce platform is buying your product and then selling, then you need to be cognizant as to whether those rules are followed or not. One good thing which is clarified in regulations is that for services, e-commerce platforms can receive 100% FDI. And therefore, if the platform in question is only dealing in services, and it could be software as a service also, and any service sold online on an e-commerce platform, that platform can get 100% FDI under the automatic route. The only thing to be kept in mind is that there should not be a mix of goods and services on the platform. That's about the FDI piece. About non-FDI piece, I think the biggest issue that I see people grappling with is tax. And with the new equalization levy, it has become slightly murky, at least when we talk about import of software, particularly people who are targeting Indian consumers for their softwares and software related services. Earlier, like I said, there was a concept of royalty which one had to pay. This is a tax deducted at source, and therefore that tax of 10% had to be paid. There is a huge debate in India around whether this tax should be paid or not paid, because in a lot of cases the foreign seller does not pay this to the Indian buyer, but the Indian buyer is expected to pay it to the government. To add to it, now there is a 2% equalization levy, and this should ideally settle the debate and only 2% should be payable. But right now, since both of them are concurrently out there, it is quite difficult to say which one is the correct position of both of them. Back to you, Gautam.
Very interesting. Now, I've actually had a number of questions coming on a number of topics here. Samir, there's a very interesting question around the regulation. Now, this kind of a product device platform is quite common in the American and European markets. Is there something India can learn from the regulations there in those markets, Samir?
Oh, I think that's a very reasonable question, and frankly, there's a lot to learn, because of course, with the years and years of experience that the Western world has had, their regulators have come out with far more nuanced guidelines around, for instance, looking at standalone software, looking at software that are accessories to other medical devices, are software bundled with hardware. So there's a lot of detailing that goes into the risk-based classification and more importantly, exemptions. What will happen very differently is that a lot of personal well-being applications and for that matter, other kinds of medical devices which are software, they may not be treated as medical devices in their home jurisdiction, but because of this entire development, they may be treated as medical devices here. So one hopes that the government takes a little bit more time in terms of policy advocacy as well. The rules which have been introduced now, they were in draft form for 30 days, inviting comments, and within 90 days thereafter, the government came out with rules. I think that's a very short period of time for the government to fully evaluate all implications of such changes.
Samir, another question, just hang on there. And this has to do with product liability. Does it create any product liability issues that one needs to be aware of?
Well, yes and no. Let me start with the no. No, because it doesn't, to my mind, create a lot of new product liability issues. And that's because we have what is called a Consumer Protection Act. What we have in vogue is a law of the 80s. There's something which has come about last year, and the replacement transition is still ongoing. It still hasn't fully taken effect, but that does introduce a slightly harsh product liability concept. So it's not really necessarily a question of negligence anymore, and it's more a question of saying what harm at all is caused to the consumer. So from that perspective, there was an element of product liability which was forthcoming nonetheless. But by way of inclusion in the entire list of medical devices and drugs, as they call it, you do fall within some very draconian and high octane liabilities under the Drugs and Cosmetics Act. But again, some of those involve prosecution and really very egregious circumstances trigger those. So I won't think pragmatically they're a huge risk, but yes, on paper, they definitely do pose something to worry and think about.
One more question, Samir, a very interesting one. You see, most of these apps typically get updated, upgraded, time. Every time this app gets upgraded, do you have to go and apply for a fresh registration?
Well, the way I see it, it really depends on what is the extent of the update. And if the update is really fixing bugs or fixing or tweaking small things here and there, I don't believe that each update would need fresh registration. But if you're introducing, say, a new set of services by way of an update to the app, and it's all folded into the initial pricing that you provided, I'm not entirely certain whether you could escape the exemption and the registration being done afresh. Of course, this will also depend on how you describe the product in the first registration to begin with. So it will involve a lot of thinking around how you make your initial filing.
Very interesting. Shupratin, there's another question for you, and it has to do with the conditions of software and apps. Should the terms and conditions of software and apps be modified? And if so, how? Very interesting question.
Yeah, so of course, like I was mentioning during my presentation, that if there is any requirement to modify any aspect of your terms and conditions and privacy policy, you should be very clearly stating that to your consumers. And because you are handling sensitive personal data, you have to be mindful that you are really enumerating all the relevant elements that I spoke about during my presentation in the privacy policy and terms of use. It is going to become even more rigorous under the Personal Data Protection Bill. But do ensure that if you are handling sensitive personal data or information, you have all the elements there. Thank you, Gautam.
Well, actually, I'm just looking at my watch here. There's a lot many questions here. What I'm going to actually encourage a lot of the people to do is we're going to obviously share a copy of this presentation and the recording with all of you. We will also share the email addresses of all the speakers on this panel here. And please feel free to drop in whatever questions, clarifications you have on this subject matter. This is an interesting, evolving topic in the Indian context, and we are all in these uncertain COVID times. So innovation is the key here. And if medical devices, PPEs, as Samir said earlier, they fall in the same bucket, have some scope to maybe try and take care of this problem at the current stage. I think it'll do a lot of good for mankind, not only in India, but different parts of the world. And with that, I'll actually try and draw this webinar to a close. Thank you very much for taking the time. I will also like to thank all my fellow panelists, Samir Shah, Shupratim Chakrabarti, Adish Nargulkar, and Sanjay Khan Nagra, to really try and help us get a good snapshot in terms of what this regulation around this new law really means. Yes, thanks a lot, and stay safe. Good evening.
Thank you. Thank you, everyone.
Thank you.
Thanks,
Thank you.
everybody.